Welcome back. I call this meeting to order. Welcome to meeting number 106, the House of Commons Standing Committee on Government Operations and Estimates. Committee is resuming its study on the changeover of the public service healthcare plan from Sun Life to Canada Life. And then at the very end, as I mentioned, we'd promised Ms. Vignola a couple weeks ago that we would get to her motions. So as soon as we're done, we'll attend to the order production motion that Mrs. Vignola had. So pursuant to Standing Order 1082 and the motion adopted by the committee on Tuesday, October 17, 2023, committee is meeting on the study of the changeover of the public service healthcare plan from Sun Life to Canada Life. Reminder, as always, do not have your earpieces next to the microphone as it causes feedback and potential injury to our very valued interpreters. We have Ms. Hart and Mr. Savant, sorry, with us today. I understand you have an opening statement for us, sir. Please go ahead. The floor is yours.
Thank you very much. Morning, everyone. My name is Seth Sazant, and I'm a Pension and Benefits Officer and Negotiator with the Public Service Alliance of Canada. I'm appearing on behalf of our National President, Chris Elward, and with me is my colleague, Sasha Hart, PSAC General Counsel. Thank you, Mr. Chair, for the opportunity to speak on this very important matter. Of our 225,000 members, the majority work for the federal government, where the benefits are provided through the Public Service Healthcare Plan. In addition, hundreds of thousands of retirees who are former PSAC members are members of the same plan. While we negotiated the terms of the plan itself, it's the employer's obligation to administer and to provide those benefits. On July 1st, 2023, Canada Life took over the administration of the plan. And since that time, to say that things have been a total mess is an understatement. The ability of our members to contact Canada Life for routine issues, questions, and reimbursement for regular services has appeared to improve. However, many problems remain. We believe that there needs to be discussions on ways to make things right for what has gone on and to fix the existing problems. Phoenix was bad enough. Our members have dealt with not getting paid properly or on time for years, and now accessing their benefits has become incredibly difficult. The employer has repeatedly fallen down on providing the basics of compensation for our members. I'd ask the committee members to consider some of the following situations. Each one's a real-life situation of a PSAC member or retiree who's contacted us asking for help. One member who suffers from a neurological disease was unable to complete positive enrollment and couldn't get in touch with Canada Life to fix the issue. As a result, they discontinued their pharmacotherapy, suffered from multiple seizures, and were hospitalized. A cancer patient who requires biological therapy medication that costs $5,000 a month had their claims seamlessly covered with Sun Life, but were then denied by Canada Life. They ran out of medication because they couldn't afford to they couldn't reach anyone at Canada Life, and they couldn't afford the out-of-pocket costs. Another member's spouse requires medication that costs $2,300 per month. It was covered without issue previously. Canada Life then halted their coverage, and months of unresponsiveness led to over $8,000 in out-of-pocket expenses. I'd ask you to put yourself in these people's shoes and imagine the stress and difficulty. These members should have been focused on fighting their diseases, but instead they were needlessly spending time agonizing over how to get their medicines covered. And for some, this meant a decline in their health. For months, members who called Canada Life had at best a 50-50 chance of even getting into the queue to wait on hold. The other 50% would simply hear a message saying, "Call back later." For months, the average wait time for those who were lucky enough to get through was over half an hour. Now, the contract that the government has signed with Canada Life stipulates that over 70% of calls should be answered in 20 seconds or less. Now, we also saw problems with insufficiently trained agents offering incorrect or misleading information and very slow processing times for claims. Again, the contract stipulates that 95% of claims that are submitted electronically should be processed in 5 days, but routinely there was a 5-week delay. If Canada Life cannot adhere to the service standards in their contract, they must provide fee credits back to the Government of Canada. but they were given a 6-month grace period where such credits did not apply, and we're still puzzled why this was allowed to happen. Canada Life forced our members into terrible situations without even coming close to the expected service standards. These standards remain unmet as far as we know, but we haven't been provided with the figures that we'd need to verify this. Now, all that said, we're seeing two continued major problems with the administration of this plan. The first relates to international claims. So members who are posted abroad, working in Canada's embassies, consulates, military bases, or anyone who's traveling, the entire system is actually currently down and has been for 2 weeks. This is the result of a cybersecurity incident. However, even before this complete shutdown, service for members outside of Canada has been a major issue with an enormous backlog of unprocessed claims. There are currently more than 3,500 claims that are over 60 days old waiting to be adjudicated and paid. The second major problem relates to a process of prior authorization for drugs. This is a new process where people who take certain drugs, usually due to their high cost, must navigate a system of approvals before any coverage. This system is failing our members and causing serious health issues for many. Be happy to elaborate further if there are questions. Now again, certain problems are definitely getting better, but many problems remain. And there isn't an easy fix here. But fundamentally, we believe that our members need to be made whole for their pain and suffering. This includes those who have suffered adverse health consequences and for those who have suffered financially. Thank you very much for your time.
Thank you very much, sir. We'll start with Mrs. Cusi, please, for 6 minutes.
Thank you, Chair, and thank you very much, Mr. Cezanne and Ms. Hart, for being here today. Very much appreciate it. The negotiations with Canada Life on the new healthcare agreement were meant to be between the unions, retirees, and the Treasury Board. Do you feel that your organization was properly included in these conversations and the creation of the new plans and its terms?
Thank you very much for the question. I'd like to differentiate between two separate processes that happened on July 1, 2023. One process was the implementation of what was negotiated between the parties, the unions, the retirees, and Treasury Board, to implement a number of changes to the plan itself. Canada Life was not party to those discussions. Canada Life had nothing to do with those discussions. The second change that happened on July 1st, 2023, which is at issue here, relates to the change in insurance providers. So Sun Life used to administer this plan, and on that same day, again in a completely different process, Canada Life took over the administration of the plan. And so what we're hearing in terms of these problems relate to the administration of the claims and the delays in reimbursement of members' claims. And on the issue of moving to Canada Life, this was not something that was negotiated. This is not something that the unions are party to, nor the retirees. This was a change that was entirely under the purview of the employer.
Okay, thank you for that. I'm sure you're aware that this committee has been seized with the ArriveCAN study, and since both of you are here today, I thought I would take the opportunity to ask some questions relative to that study as well. We've been studying the increasing use of both subcontractors and contractors by the government. What would you say is the feeling of public servants relative to the consistent use of outside contractors instead of relying on internal expertise? Would you have any comments on that, given your presence here today?
Again, appreciate the question. I think as a general principle, we've seen a lot of difficulties and problems when it comes to the hiring of outside contractors. I do want to, though, caveat here that I'm certainly not an expert on contracting out or contracting in. I can speak to this particular issue, which is the contract with Canada Life or with Sun Life. This is something that has traditionally been done where there is an outside company that administers and adjudicates benefits. And so I wouldn't really want to get too far into the concept of contracting out or contracting in. That's definitely not something that I feel that I'm able to do.
Certainly, Mr. Stanton, I appreciate that. But being a pension and benefits officer, I would just genuinely feel you have the pulse of the public servants. It was found that resources used on outside contractors on ArriveCan were paid almost double the amount per day that public servants were paid for the same work. Has this been an issue that the union has encountered before? Is there any other instance you can think of where this has occurred?
Again, without speaking to specific examples, we'll say that we believe our members provide very good value for money, do excellent work, and oftentimes we certainly have seen studies that bringing things back in-house often does save money rather than cost more money. But again, these are general comments, and I'm going to keep those comments there. Thank you.
Certainly. Back to the plan. Would you say that the members in your discussions with them have appreciated the benefit increases, or has this been overshadowed by the major changes to coverage in things like physiotherapy and prescription drugs, for example, if we want to go back to that for a moment, please?
Again, thank you very much for the question. The changes in coverage were quite extensive. I think there were over 70 benefit increases that we negotiated to many different provisions. The plan hadn't been updated in any meaningful way since 2006. Some minor changes had occurred since that time, but as I'm sure everyone can imagine, changes to healthcare provision, changes to costs for healthcare have increased, and there had not been increases since 2006. So we did negotiate many increases, but in the course of negotiations, of course, there's going to be some give and take, and we have certainly heard from members as well. But on balance, we believe what we negotiated provides some very strong value for our members.
Yep. Thank you, Mr. Sun. Back to your opening statement, you had indicated a recent breach which is providing difficulty for Canadians posted abroad. As a former diplomat, I'm very troubled by that. In ArriveCan, we also saw an instance of a lack of security as a result of clearances not being issued. Would you be concerned about increases to security risks due to continued use of not only contractors but subcontractors as it relates not only to ArriveCan but to this breach and the results for public servants abroad?
Thank you. We don't actually know what the breach is at this point. I'm not privy to the information. The union's not privy to any of that information. Obviously, we would expect that these outside companies would take our members' sensitive information quite seriously. We certainly have some concerns over that, but it has been 2 weeks since the entire site has now been shut down, and anyone who's traveling abroad or lives abroad has been unable to focus or to put in a reimbursement for their claims. So our primary concern relates to that.
Thank you for your work. Thank you, Chair.
Thank you very much. Mr. Baines, please.
Thank you, Mr. Chair, and thank you to our guests from the Public Service Alliance of Canada for joining us today. So, can you just explain the plan administrator and the plan itself? So, you indicated that the union had negotiated a lot of the plan. Like, what part of the plan? The terms, or the delivery of it, or the benefits? All of those, all of the above. Maybe speak to the pieces that you had negotiated, and then what is happening with the administration of it.
Thank you very much for the question. So the short answer is yes. That the terms of the plan are negotiated jointly between all of the unions with members in the federal public sector, as well as the retirees organization and the Treasury Board. We negotiate the terms of the plan. Sun Life, Canada Life do not dictate what is covered. That is dictated by the outcome of the negotiations between those parties. And the negotiations concluded for this plan back in August of 2022. So this was a full 10 months before the changeover from Sun Life to Canada Life. And so there was significant lead time for Canada Life knew that they had obtained the contract 18 months before the changeover. So 18 months they knew they had the contract. 10 months before the implementation of the contract, they knew the exact terms that they would be responsible for adjudicating. So there was significant lead time. But when July 1, 2023 came along, there were no surprises to Canada Life at that point. Yet the administration of this plan and people's ability to call in, have their basic questions answered, have their claims adjudicated, was just in complete disarray for months.
So ultimately, even given that they had such a lead time, the delivery of it, of the service, still they were unable to. So like, so the wait times you indicated have gotten better. I believe I recall maybe in the summer we had the wait times were a certain number. Where are we at now with the wait time? So 30 minutes on average, less than a minute. Where are we with the wait times on these calls?
The wait times to call in to Canada Life, again, say there have been significant improvements there. We're provided with some general information, the union, but we're actually not provided with all of the information that relates to the call center metrics. As I understand, at this point.
So, do you have like an indication of like say backlogs, and have they caught up? So maybe speak a little bit about that.
Absolutely, I can provide some information on backlogs. We have significant information about backlogs that relate to the international claims. That's one issue that I can speak to right now. For any international claims, there are currently 7,000 claims that are more than 30 days old that have not been adjudicated. 3,500 claims that are more than 60 days old that have not been adjudicated. Certainly, if asked, I can talk about the system of prior authorization, where we have approximately 1,000 claims that have been made that are waiting on that are at least 2 weeks old. People asking for specific medication have not been adjudicated. When it comes to Canada Life, in a more general sense, again, I'm certainly happy to get back to you on the numbers of exactly what that backlog is.
Yeah, if you could email the committee in writing on that. All those service improvements you're saying, you indicated that they have been made. What are some of the main concerns you're hearing from members in general?
Thank you very much for the question. The issue of coverage for any international issue is a significant issue that we're hearing about, and this relates to people who are out of country, whether traveling or posted abroad. And this is incredibly problematic because those who are posted abroad.
So I'm just going to stop you there just because of the time. So this seems like that's one of your main concerns here. You mentioned that a number of times, the international piece, that we're looking at somewhere around over 7,000 claims. Like, what concrete actions have been taken to mitigate this now? Have you heard anything that how is Canada Life tackling that now?
You have about 30 seconds for an answer, please.
Okay, so the service is subcontracted to a company called MSH by Canada Life. Again, we're at arm's length from Canada Life. We don't interact directly with them. This is done it's the employer's obligation. They have the contract. We don't even have a copy of the contract between the employer and Canada Life. We can't intervene with Canada Life. What the employer is doing here, we're not entirely sure. I'm sure the steps have been taken, but we don't think that's sufficient.
Mrs. Vignola, please, for 6 minutes.
Merci, Monsieur le Président. Merci, Monsieur.
Thank you, Mr. Chair. Thank you, Mr. Cezanne and Ms. Hart. Thank you for being with us. Mr. Cezanne, we have received the briefs, personal briefs of emails from those who have been hurt by this. A new father did not receive his response when he was on parental leave, and there was a call that was not followed up on. A woman got a drug prescription to deal with her cancer, and Canada Life refused this treatment. despite repeated explanations from the oncologist. So apparently the insurer has more knowledge on this than the oncologist. Can you please give us statistics on the number of people whose lives, financially and in the general sense, their health and so on, were jeopardized by Canada Life's practices? Thank you very much. I'll answer in English, but thank you for the question.
We don't have specific figures to respond directly to your question about how many people whose health is in danger. We have heard, I will say, from countless members, absolutely, that had serious concerns about issues with their health, issues where Canada Life has been unresponsive, where they've been unable to get through. And we have specific concerns about how many people's health has been put in danger. Certainly couldn't put a number, but I would imagine that number is awfully high. With respect to the situations that you raise, these are very common, unfortunately, situations that we hear from our members about. I wish these were one-off situations, but I think those are both very good representations of what we have been hearing from our members and concerns that we have. One of the issues I think that this may well be related to is the system of prior authorization for drugs. And you mentioned, someone who has issues specifically, who has cancer, who's trying to get approval for a drug. There is a process that's in place for certain high-cost drugs that people have to get approved for that drug. Now, this system is in place and is fundamentally failing our members. Now, there was a system that was negotiated between the parties, that this was something the employer insisted upon as part of the deal, our negotiations for the provisions of the plan. And we asked many questions about this, about how, if a member's refused, how do they appeal? How long will it take for Canada Life to turn their decision around? And we were told that this would be quick, this would be swift, and this would be painless. Now, here we are 8 months into this contract, and we are getting figures that there are more than 1,000 people who have been waiting for more than 16 days on even an answer from Canada Life. So you point to someone who's been denied, but there's many, many people who are just sitting there waiting to be told whether or not they're able to get the drugs that they need on a decision from Canada Life. And their health is at risk, and we absolutely have major concerns about the way that this is going.
Merci. Rapidement.
Thank you. Very briefly. Now, as for the cyber incident with MSH International, did the participants in the plan find out like I did, that is to say through the media? Yes. So no communication from the company itself in order to support the participants, or even to say call an overloaded call center.
There may have been communication to members about this. I am not aware that that has happened.
Comme participant. Il poursuit.
Canada Life required the transfer of the last 10 years of history for participants and for their dependents. And this, even though these individuals became adults, they no longer had access to insurance. Is it normal that a company require the transfer of personal information over 10 years without informing the participants and their dependents?
I want to be clear, your question relates to keeping the data and the safety of that, how long that will be kept for?
Non, le transfert des données.
No, this has to do with the transfer of information between the two companies over a 10-year period.
I'll be frank and say I'm not. These are a level of detail in terms of the provision, the data that's going from Sun Life to Canada Life. Obviously, security is a major issue when we're talking about any participant's data. Again, we're not provided with the contract. We've asked for the contract between the government and Sun Life, the government and Canada Life. We have been refused the provision of that contract, which likely will then contain those provisions. So we're actually not aware of what those provisions are.
Juste le fait que personne n'ait
And the fact that nobody was informed of this transfer, well, does that concern you?
I mean, there's an awful long list of issues that we're concerned with when it comes to the provision of our members' information and the administration of this plan. But appreciate the question, and absolutely, we have significant concerns.
Merci.
Thank you very much. Mr. Bachrach, please, for 6.
Thank you, Mr. Chair, and thank you to Ms. Hart and Mr. Cezanne for being here today. Obviously, this is an issue that's very concerning, and I hope the committee can get to the bottom of what went wrong. And maybe I'll just take it up to 10,000 feet and ask you where you think things went wrong. Obviously, you don't have all the information. You said you don't have the contract. You weren't privy to the process by which it was negotiated, but something has clearly gone sideways here. Either the government failed to negotiate a contract with Canada Life that is in the interest of your members, or Canada Life has failed to uphold the terms of the contract and has left your members high and dry. Which of those do you think is the case?
Well, I don't know that it's necessarily an either-or question. I think that there's probably there's going to be some issues on both sides. I think certainly concerned that, as I'd mentioned, that there's a 6-month grace period in the contract where there are very few safeguards. I think certainly people are probably surprised at the level of how poorly they performed according to the call center metrics and the other provisions that they're supposed to be following. I think without getting too speculative here, I think there's definitely significant shortcomings that happened on the part of Canada Life, and I think that the contract probably is that the employer signed with Canada Life has there's some bearing there that of why we're in this mess.
So, staying at that 10,000 foot level, what does accountability look like, and who should be responsible for ensuring that your members are made whole?
Sure. Thank you for the question. So we would say that accountability lies primarily with the government as they negotiated this contract. So we would expect, for example, that they would enforce the service level standards that are contained in that contract. In terms of making our members whole, that's actually that's definitely a priority for PSAC. And so recently, PSAC filed a policy grievance against Treasury Board, arguing that in terms of the poor transition of the plan's administration, it has failed to protect the rights of members to a functioning healthcare plan, as well as caused adverse impacts on members with disabilities and other intersecting identities. And so as part of that grievance, we are asking for general damages for the pain and suffering and stress that this transition has caused. We are asking for financial compensation for those who incurred financial losses as a result of the poor transition, and as well as a declaration that the way that this has been managed has indeed breached the collective agreement as well.
Thank you. Reading through some of these examples, these stories, it seems like these are difficult situations to account for financially. Because obviously these people's lives have been profoundly affected. But that would certainly be a start to recognize the depth of the impact that's been imposed on these folks. You mentioned the issue of prior authorizations. I'm wondering if you can describe how well that was working under Sun Life, under the previous contract, or is this a longstanding problem that has been a problem for people for a long time, or is this really something that has cropped up with the new contract with Canada Life?
Thank you for the question. This is new because this was a new provision to the plan itself. This was something that the employer very much wanted to introduce to the plan, and during negotiations, this was something that we felt that we did not have much of a choice in terms of ultimately settling with some form of prior authorization in place. Our concerns during that process related to members appealing, concerns about members with with very fragile health conditions that would need approvals or at the very least a decision to then examine other options within a reasonable time frame. We're absolutely stunned that it appears as though the system is just not working at this point. There's no answers. But again, this is a totally new system. We were assured that this is, this will work seamlessly. This is going to go, people will get their answers quickly and we'll have the chance to appeal. But clearly that hasn't been the case.
You mentioned the MSH International, the subcontractor that's responsible for the coverage for members working abroad, and the issue of this cybersecurity breach. Whose responsibility is maintaining the cybersecurity of the claims system?
That's an excellent question. The company MSH is the one who is feared to have been breached. Whether Canada Life is ultimately accountable for the breach itself is a question I don't know the answer to. Ultimately, Canada Life is the one responsible and accountable for the administration of the benefits generally, whether it's subcontracted or not. But I think also to directly answer your question, it's I'm not sure who ultimately will be accountable within their own contracts.
That's it.
Thank you very much.
Thanks. Perfect timing. Mrs. Block, please.
Mr. Chair, and thank you to our witnesses for joining us today. It's been some time since we held our first meeting on this issue, but happy to return to it and ask some questions of yourselves. We learned at the very first meeting that it is not the industry standard to conduct manual enrollment when transitioning plans, but that this was actually a requirement put in place by the federal government, and that the purpose was to use the transition to refresh data and use Canada Life to remove those who should no longer be eligible for benefits. Were you aware of that requirement that was put on this transition by the federal government?
I think there had been some discussion. Thank you very much for the question. There had been some discussion about positive enrollment to ensure that there are those who are in the plan are correctly in the plan. And in a general sense, I will say that as the union, we don't object to that. I think that that's fair. That being said, clearly the process that was used was absolutely atrocious. To load in all of these things at the same time led to a huge bottleneck. And I think where we also saw significant problems is a number of our members and retirees all having a lot of difficulty navigating this process. So while there was awareness, this isn't something that we asked for. And I think that obviously this created significant problems along the way.
Thank you. You also spoke about a 6-month grace period where there are very few safeguards. Really quickly, what would you have expected to see during that 6-month grace period? I know you provided examples of individuals who discontinued their medication because they couldn't get through to Canada Life on the phone, but what kind of safeguards would you have wanted to see? And in a short answer.
Absolutely. What I'm referring to is the service standards that exist in the contract about how quickly they must respond to calls, how quickly the administrator must reimburse the benefits, and the fact that there's essentially that 6-month grace period before any of those standards were enforced. And so certainly it would be our position that that's just unacceptable. It seems like maximum advantage was taken of the fact that there were no safeguards there, and so we would certainly question the wisdom of providing essentially completely open-ended service standards in those first 6 months.
I appreciate that. I know a number of my colleagues have raised the issue of the breach, whether there's one or more, and I want to follow up on those questions because I think breaches of information, security breaches, data breaches are very concerning. And I want to just ask, have you or your members been notified? Were they notified about the possible data breaches over after the changeover was made to Canada Life?
Thank you very much. Just want to be clear that the recent breach dates back about 2 weeks ago and specific to MSH, the international provider under the plan. While as representatives, we have been notified that there is a breach. I'm not aware that general notification has gone to members about the breach. And we're not aware any more than other people in terms of what we've read in the media is really the extent of our knowledge of what's happening with the breach right now.
So is this not deeply concerning to you as representatives of the public service and members in this plan that you have not been given any details about the breach? You've only had to read this in the news. It raises very serious concerns for some of us at the committee, given, and I'm going to speak to what we've recently been dealing with, given the Auditor General and Procurement Ombudsman's both reported that security requirements for contractors and subcontractors were not met and sometimes were reduced as identified in the procurement process for ArriveCan, and that could be being replicated in other departments. And so I guess, you know, I hear what you're saying, and if this led to data breaches in the process of smaller groups of Canadians, though still a significant size, it does raise serious concerns about the safety of the data collected, not only through ArriveCan, particularly because of the sensitive nature of the information, but given your members and any kind of data that may have been breached, and the fact that you've not been told exactly what's happened. Would you agree with that?
Quick yes or no, please.
Absolutely, we have concerns.
Thank you.
Thanks very much. Mr. Jawari, please.
Thank you, Mr. Chair. Welcome to both of you. Mr. Cezanne, you opened your remarks by talking about the impact that this transfer has had on the PSAC members, and you share some of those in quite detail. I just want to also acknowledge the fact that this was not an easy period, and our side is very much committed, as I'm sure every member of this committee as well as this House is committed, to ensure that those issues are addressed very quickly. But we acknowledge there were challenges, and some of these challenges had the potential life-changing implication, and it needs to be mentioned, it needs to be acknowledged, and it needs to also communicated through you and the council back to the members that we acknowledge that, we hear that, and we are here to work collaboratively to ensure that it goes. It was also good that Ms. Hart talked about the how the process for making the members whole is going. You highlighted a number of factors that you're working on around general damages, around financial compensation, and around reviewing the declaration. You also mentioned, Mr. Cezanne, you mentioned about the fact that this plan had not been updated since 2006, I recall. And in your opening remarks, you talked about that close to 17 new benefits and updates were given. Can you give me a sense of, in general, how many benefits are the PSAC members are receiving? 100, 500, 1,000 benefits? And where does this 70 kind of lines up with? Is it 10% of the benefits? And how significant those benefits were or are? Sorry.
Thank you for the question. I think these things are tough to quantify. When I referred to the benefit improvements, it was, so for example, if we want to talk about somebody who's the different paramedical maximums, so psychological services, that was the maximum that someone can be reimbursed for psychological services, that increased. So that's, when I'm counting them, that would be one of the increases that I'm counting.
What was it and what did it go to?
So the psychological services, there was a substantial increase from $3,000 to $5,000. But in terms of the benefits, it's tough to quantify because there's a lot of benefits in there that relate to whether it's drugs, whether it's different medical supplies that people may need that wouldn't really go through and count them. So at the end of the day, there was a negotiation process that happened where there was an update to quite a number of benefits that have a maximum eligible amount. And so having not been updated for 15 years, you can imagine that same dollar amount will be worth significantly less 15 years later. And so that was part
well,
of
I
the
just want to
process.
thank you for doing that that doing negotiation as an advocate for mental health. That was one of the areas that I right away looked at because just for transparency, wanted to avail myself to it, and I realized that it's substantially increased, and thank you for that. I would like to understand what's the impact of these 70 new benefit from a process point of view, because naturally, whether it was Sun Life or whether it's Canada Life, these are new benefits that's coming in. And what's the impact on the process? Is it a new process that has to be defined, or existing processor for claim processing has to be put in place? How significant this? Had we had Sun Life, would that been as easy, or still would have had a huge impact?
Thank you very much for the question. The vast majority of those benefit increases were of the variety that I just spoke to, where it's a simple change in the maximum eligible amount. So it went from, as I mentioned, with the psychological services and with many of the other benefits, it was simply an increase to how much members are able to take.
We got 30 seconds left, but I just want to go back to that. So basically, what I'm hearing is you're saying, well, we just increased the amount. But for example, was cognitive therapy before was covered under the plan? Was only psychotherapy, or was it psychology, or any of those? Because I believe there is also expansion of the type of services, especially as it relates to the mental health, that it also expanded, whereas, before it was not there.
That's correct. There was some complexity, but my point was simply that most of the benefits was a matter of just a number change.
Thank you. Thank you, Mr. Chair.
Thank you, sir. Mrs. Bignola, please.
Merci. L'entente.
Thank you. The agreement between Canada Life and the Government of Canada did not require 100% of the participants to have access to the RSS, to the PSHCP. The agreement between Canada Life and the Government of Canada did not require any exceptions by the contractor and users when it comes to communication services. Do you consider that Canada made a mistake in not requiring any trials and making sure that 100% of participants were not covered as of July 1st?
I'm sorry, I'm struggling to understand the question with respect to trials before 2023. My apologies. I was listening to the translation. I'm still not sure that I understand the premise of the question.
Dans le fond,
essentially, there were no trial tests for acceptance trials for the entrepreneur and the users to make sure that it would work. Since Canada didn't do those trials and accepted that not 100% of people would be covered, did they make a mistake in their decision?
So just I want to ensure that I'm correctly understanding, talking about with the conversion, moving from one contractor to the other to make sure that everything was smooth in place. And my apologies for that. But there was and remains that the Public Service Healthcare Plan has an administration authority that is responsible for oversight of this contract. And they have been working very diligently 18 months before the move from Sun Life to Canada Life. They spent 18 months working to ensure that things would go smoothly. Now, obviously, that was not the case. But there was substantial work that was done beforehand. Want to be clear that this was not just we'll flip the switch and see what happens. There was significant work that did go on behind the scenes.
Rapidement, Madame Hart, vous avez...
Thank you. Very quickly, Ms. Hart, you heard my questions. You heard about the problems. As council, your recommendations to take action for unionized individuals, what are they, and have those measures been taken?
Brief answer, please.
Thank you. Yes. So, in terms of our recommendations to members, we are in the process of making sure that our members have all the information they need to be able to assess whether their situation should be best dealt with through the PSHCP appeal process or whether their situation would be appropriate for the grievance process. So, we are prepared certainly to assist our members to file individual grievances to address some of the issues they've experienced and to get compensation through that venue as well as the broader systemic policy grievance that we are filing in each affected bargaining unit as well.
I have to cut you off there. Thanks very much. Mr. Bachrach, please, sir.
Thank you, Mr. Chair. I'm coming into this study partway through, and so there's some of the testimony I'm less familiar with. But I assumedly PSAC has talked to the government about these challenges. I'm wondering if you can characterize the government's response and whether it's been adequate, and whether you're familiar with some of the testimony the committee has already heard, and what we should make of that.
Thank you very much for the question. We were certainly paying close attention during the testimony, the last meeting that occurred for this committee. We hear concern absolutely from the employer's officials, but what we're most concerned with is less about what they say than what they do, and we think that we do see some improvements happening, but we think that there's still an awfully long way to go here, and we certainly will need to see our members be made whole at the end of this process for those who have suffered health consequences, financial consequences, and this isn't theoretical. We're still in the process of been speaking with a member very recently who's carrying more than $8,000 on their credit card because they don't have any way to be reimbursed.
We haven't seen the full terms of the contract, but I think we can assume that the 6-month grace period makes it difficult to secure accountability from Canada Life, to force Canada Life to make those members whole for the problems that occurred during that period. Do you believe that it's then the government's responsibility to make your members whole for things that they suffered during that 6-month grace period?
Yes, that portion and beyond, we believe that ultimately it's the employer that's accountable to provide the benefits that they have promised to our members.
Thank you, Mr. Chair.
Thanks, Mr. Bachrach. Mr. Genuis, please, for 5.
Thank you, Chair. I'm going to address my questions to Ms. Hart, General Counsel for the Public Service Alliance of Canada. Thank you for being here. We have seen in the course of the last 8 years with this government significant growth simultaneously in the public service and also in spending on outsourcing. You would expect that these things would be, in some sense, inversely proportional, that if you had more capacity in the public service, you would have less outsourcing, or if you had a declining public service, you might see more instances of outsourcing. But strangely, we're seeing growth on both of those levels. We're expanding the public service and we're sending more work outside of government. This committee, as you know, has been doing work on the Arrive scam scandal, which seems to demonstrate not only are we outsourcing, but we're actually outsourcing the process of outsourcing. That people, in the case of GC Strategies, were not hired to do work. We outsourced the process of doing the outsourcing. And this is particularly bizarre to me. It seems that the public service, if they don't have the capacity to do certain work internally, they should at least have the capacity to be able to directly identify the people that can do the work and do that outsourcing work directly, rather than having multiple layers of outsourcing in between. I wanted to ask if PSAC has made representations to the public service, or to senior levels of public service, or to ministers directly about these issues of outsourcing. What kind of conversations have you had with ministers about this, and what kind of feedback have you gotten?
Thank you for the question. So I think this might be one of the issues where, in order to provide a more fulsome response, we may want to submit a brief to the committee afterwards. But I can say, and as my colleague mentioned previously, that the issue of outsourcing is of huge concern to PSAC. It is an issue that is raised at the bargaining table. It is an issue that is constantly raised, at the political levels. So we would definitely agree with what you've said and share those concerns, absolutely, and we'll continue to, through the avenues that I've mentioned, try to address the problem of over outsourcing, because as my colleague said, we do think that it's a more efficient to use the members that we have.
Thank you. And I think this committee is very interested in PSAC's perspective on this issue. So if you have additional thoughts you want to provide to the committee in writing, I think there are different aspects of the Arrive scam work we've been doing. There's the particulars of the scandal, of course, missing records, rigged processes, but there's also the question of how this government is allowing so much money to be spent, outside as well as inside government. I want to ask you about another aspect of that, which is concerns about reprisals against public servants following testimony at this committee. We had an instance where two senior public servants appeared before this committee, gave testimony in response to questions that was critical of people that they reported to. They were immediately after that told that they were under investigation. They were subsequently suspended without pay in the middle of an investigation. How rare is it that this would happen? And what are your reflections on this suspicious timeline, this suspicious train of events?
So PSCC is concerned about any incidents of reprisal and retaliation, and this is why we see things like adequate whistleblower protection legislation, which we have been advocating for years upon years, as being absolutely critical. So in terms of the specific situation that you've referred to, I don't know that we have details on those individuals. So I'm unfortunately not able to speak to that. But
that's okay. But maybe if I can just ask you at a general level, I'm getting the impression from what you said that you think whistleblower protections are not adequate right now. So if you could comment at a policy level on whistleblower protections in a hypothetical case in which somebody may have seen something on a scandal issue that they want to be able to share frank evidence with a parliamentary committee, and they have an obligation, frankly, to respond truthfully to questions that are asked. Do you think the protections are adequate for public servants to be able to do that or not?
We would say that they definitely need to be improved and enhanced. We have made submissions in various forums before on this issue, and we would be happy to kind of collect that and gather it for the committee if that would be useful. I'm just going to turn to my colleague as he may have something to add on this issue as well.
I simply want to add that this is an issue, whistleblowing, we have brought to the bargaining table for multiple rounds now, tried to get better language into our collective agreements because we have heard from our members fears about reprisals and whistleblowing, and we have, every time we have been uncategorically rebuffed at the bargaining table.
Interesting. Thank you very much.
We have 15 seconds.
Oh, sorry. I thought I had 5 minutes, not 6. But I'd take it, Chair.
We'll turn it over to Mr. Kuzmierczak.
Thank you to our witnesses. I appreciate your testimony. This is very important, and I think if you want to follow up in writing on the whistleblower protection as well, I'm very concerned about it. It directly impacts our work as a committee. So we need this information.
Mr. Kuzmierczak.
Thank you, Mr. Chair, and thank you very much for being here with us today and shedding some light on this concerning issue. Again, it's to see the challenges that our public sector workers and retirees had faced during the transition. It's reprehensible, but we're happy to see that there is some progress being made here to iron out those challenges. You mentioned that this was the most significant update that we've seen in the PSHCP since 2006. Over 70 changes that had been hard fought and won. And I wanted to ask you about one in particular. In sort of the communications that I've read and heard, obviously it was depicted as a significant victory for the LGBTQS community. Some of the changes that were introduced, specifically around coverage for gender affirming care. Are you able to speak a little bit about those changes that were introduced and why it was so important for your membership?
Absolutely, and thank you for the question. Yes, there was a new benefit that was introduced for a lifetime benefit related to gender affirmation procedures, and we're certainly proud to have been victorious on bringing a new benefit in for our transgendered members. This benefit covers processes and procedures that may not be covered by the public plans. This is something that has been growing recently in private insurance plans as the public service healthcare plan to provide for gender affirming procedures and coverage for those procedures. As the landscape expands, this is something that, again, we're seeing more and more often, and we're happy to very much to be able to be victorious on introducing this benefit.
So coverage is expanding for gender affirming care, life-saving care, and many would argue. Is there concern among the membership, the conversations that we're hearing from the leader of the opposition, the conservative leader of the opposition, Premier of Alberta, that there are limitations going to be placed on gender affirming care that is often described as life-saving? Is the membership concerned? Have you heard concerns on that issue?
Absolutely. I mean, we're as a union, we represent all of our members, and we take great pride in introducing new measures that do provide significant benefit for our transgendered members and our LGBTQ members. Any time that we believe that there's discussions out there that may be negatively impacting some of our equity-seeking groups, absolutely, this is of serious concern for us.
So one step forward in terms of coverage here federally, and then one step backwards in terms of access in a province like Alberta. Is that a fair depiction?
I mean, again, I'm not an expert in terms of exactly what's happening in Alberta.
Gotcha. I wanted to ask you about another change, which is the reimbursement of pharmacy dispensing fees, capped at $8 per fee. Can you speak a little bit about that, and how do we arrive at that specific number?
And, thank you for the question. Again, this was the pharmacy dispensing fees used to be unlimited, and this was something that was changed in the negotiations. This was something that was, again, insisted upon by the employer. This was an employer proposal to decrease the pharmacy dispensing fees. And in the overall context of negotiations, again, our goal was always to improve the benefits as much as possible. But like any negotiation, there's going to be some give and take. This was something that the employer brought forward, the employer pushed very hard for, and ultimately it's a part of the final deal.
Okay. And I wanted to ask you about digitalization. So there's a significant difference in claim resolution times between paper and digital submissions. Can you talk about how the membership feels about digital submissions? Have you heard feedback? Has there been increase in digitalization of services and whatnot through through Canada Life?
Thank you for the question. I think that there's a few aspects to this. The plan does cover our members, active employees. The plan also does cover retirees, and some of whom will have different levels of comfort with digital methods. I think this is also underpinned by a number of failures for the people to be able to submit electronically adequately. There's been all sorts of problems with people being able to make their submissions. Our primary concern is ensuring our members get their benefits provided, that they're reimbursed in a timely way by whatever means is going to be most convenient for them.
Okay. How much time?
About -30.
Okay, thank you.
Mrs. Kusi, please.
Thank you, Chair. Further to my colleague's question about the whistleblowing, would you please share the response from your membership relative to the legislation at the Senate currently, Bill C-290?
So, and just want to make sure that I understand your question. So, how do our members feel about that legislation?
Yes, their reaction to the contents of the bill, if they feel it goes far enough, not far enough, what changes that they would be interested in making.
So I think again, this is a critical and important question, and I know one that PSAC is highly engaged in. We do have submissions that we have prepared in the past on this, and because I don't have those with me, I wouldn't want to speak out of turn and be inaccurate in terms of what positions we've taken on that precisely. So if it would be acceptable to the chair and the honourable member, I would love to be able to provide that to the committee, those submissions.
Sure, sounds good. Further to the documentation you're providing for my colleague, Mr. Genuis. Regarding changes to the plan, are you receiving regular updates from Treasury Board as to the administration and changes relative to the plan itself? How are those communicated, please?
We do, thank you very much for the question. We do receive biweekly reports on certain call center and administration metrics. We are continually engaged with meeting with them to ask further questions and to clarify and refine some of that data with respect to how things are moving there. So yes, we're made aware, but we do believe that there's continual as new problems crop up, there's continually new questions that we need to have answered.
Okay. How was communication set up between Canada Life and members to ensure the transition would be as smooth as possible?
Communications were discussed, I think, quite substantially. There are committees that discuss the aspects of communication that we believe need to be sent out to members. But again, this is an obligation of both of the employer to ensure that members are made aware. This again was a decision made unilaterally by the employer, by Treasury Board, to change from one insurance provider to the other. And so those communications that needed to go out and those decisions were decisions made by the employer.
Me, were members made aware when they would require additional documentation to receive the same coverage for certain drug prescriptions?
On many of the changes to the benefits, there are submissions that are required to ensure that they meet the requirements of the plan. We've been engaged in constant conversation about different aspects of the plan where there may be different information required by Canada Life compared to Sun Life. Some of those, of course, relate to the negotiated changes in the plan, but on other provisions, we're hearing that there is different documentation that's required by Canada Life than used to be required of Sun Life, and that's of significant concern to us. But again, we're getting very deep into the weeds, I think, on some of the issues that we see there, and we are consistently in communication. And when we hear from our members on anything related to this, these are issues that we raise and that we ensure that we do whatever we can to clear their path forward to get those benefits.
Right. It may be deep in the weeds, but I think it's a fundamental question relative to access to the reimbursement. In my experience, far more documentation is required. Ms. Hart, in your experience as General Counsel for PSAC, have you ever formally approached the Prime Minister or ministers relative to the substantial increase we've seen of the use of outside consultants, 60% in fact, in this government? Have you ever raised this on behalf of your membership with a minister or prime ministers, this significant increase in the use of outside consultants as has been brought to light with ArriveCan?
Okay, so I will preface my answer by saying that I have been at PSAC for 6 months now, so I can speak to only this short period of time. But that's certainly a point I've made here that I'm happy to provide more information on in terms of how our leadership has escalated this issue up at the political levels. I'm happy to make inquiries internally about that. But I can say that even in the short time that I've been here, I've seen that it is a major priority for PSAC, both, as my colleague said, at the bargaining table and in the other forms of advocacy
Thank you,
we're engaged
Ms.
in.
Hart.
Chair, I know my time is up because I use this incredible thing called Time Watch. Would I be able to ask Ms. Hart to please submit that in writing?
Yeah, if you can, Ms. Hart.
Thank you very
Mr.
much,
Sousa,
Chair.
sir.
Thank you, Mr. Chair. Thank you both for being here. And I appreciate the deliberations and the concerns that you've raised. Concerns that are evident for all of us because we certainly want to make, and we would like to see, an easier transition between the providers in terms of providing the care necessary for employees. and I appreciate your deliberations over that issue. Now, do you have discussions with TBS? You get weekly reports, right?
Bi-weekly reports.
So you are seeing the advancements and the considerations that are being addressed?
There's no question that there has been improvement over recent months. I've made reference to that quite a few times, but I think that the starting point that we're measuring improvement from is pretty atrocious. And so as we do see improvements, there's still other problems and other issues that we need to see resolved.
Is it are you of the impression that they're not trying to improve, or you're of the like is there a pushback on this issue? Like, is there a desire to provide something better for employees in your mind by all party and all stakeholders concerned?
I don't think that it would be fair to characterize to say that there's pushback to try to improve the situation. I think all parties want to improve the situation. Our concern remains that we're 8 months into the transition to a new contract and we're still seeing major problems occurring. And as well, our concern relates to ensuring that ultimately people are going to be made whole for health problems that have happened and I mean, what that would even mean is a question.
But I think those are shared concerns. I think all sides have the same dilemma here. We're all trying to improve upon it. My impression, at least from what I'm hearing and from what your discussions you've been having with the other side and those that are the employer in this case. So in that respect, when we hear about whistleblowers and this notion, are you concerned that the government or the employer is acting to punish people for reaching out and expressing their concerns when we're all trying to find a resolution? Is that a concern for you?
I'm want to be clear when as PSAC, I was called here as a pension and benefits officer. When it comes to issues related to whistleblowing, I'm not an expert there. That's it's not something that I can speak to in any meaningful way. And so,
are we not freely expressing and sharing the deficiencies so we can find improvement? Is that not happening? Is that not explicit?
Again, in my role, as I've mentioned, we meet frequently with Treasury Board officials, and the goal is to improve the situation.
So we're going over these issues. We're going over the issues that have shortcomings. We're trying to resolve them, and I don't think anyone's being held back or harmed or punished. The idea is to try to find resolution. Tell me, what is your opinion now of the pharmacare program that's being proposed? We're fortunate, right? Those of us that are watching TV know that employees of government, including elected officials, have a pension, have a health plan. There's an opportunity to support. Many Canadians don't. How do you find our pharmacare program that's being proposed alongside the NDP?
I haven't seen details of exactly what is being proposed there, so it's difficult to comment on PSAC's position on what that pharmacare, what that could look like.
On the idea of why it's being proposed. Why do you believe government is looking at trying to provide similar services to all Canadians?
On record, I think we've been general supporters of public pharmacare, and so certainly we'd be very pleased to have a good look at exactly what's proposed. But I think as a general sense, public pharmacare is something that PSCC has supported.
So what members on this, those that are in union and others who have this benefit plan, do you believe it should be available to others outside?
Again, we believe in public pharmacare. We believe that people should be able to access the medicine that they require.
Right. And so the transitions were tough. So when we talk about outsourcing, who within government would be prepared to do some of the work that you're looking at to resolve?
Just a very brief answer, please.
Difficult to answer this. I don't think when it comes to outsourcing, I'm not sure that this is an example of outsourcing. Moving like that, the administration of benefits is traditionally done by an outside company.
Agreed. Yeah. Yeah.
Thanks, Mr. Sousa. Mrs. Vignola, please.
Merci. Je vais
Thank you. I'd asked you to put on your interpretation devices, please. I'd like to ask the same question as before, but with more specifics. Do unions intend to use legal recourse against the employer just as it was done for Phoenix? That is my question.
Yes, I can confirm that, yes. And one of the legal avenues that we've taken and that I've mentioned is the grievance mechanism, because that is a mechanism that we see as possibly allowing us to get around a negotiating table to resolve that grievance. And we're seeking remedies for our members in the context of that grievance, and including remedies such as general damages, remedies under the Canadian Human Rights Act, and things like that. And we are certainly exploring other possibilities as well in terms of legal avenues.
Merci beaucoup. Juste pour vous donner une idée.
Thank you very much. Just to give you an idea of the problems that MSH is causing, I just received an email from a man who is abroad and who does not have a response for his thousands of dollars in claims, and he's going to be filing other ones, and he doesn't know if the ones he's already submitted have been seen or received. So that gives you an idea of the kind of stress that this can cause. I have less than 1 minute left. I would like to table a motion that we can then debate later. It goes as follows. That the committee requests the Auditor General of Canada, AG, to 1, conduct an analysis of the contract between Government of Canada and the Canada Life Insurance Company in relation to the Public Service Health Care Plan. 2, to compare the services offered by Sun Life of Canada with those offered by Canada Life, and to report to the committee as soon as possible. The motion should have already been distributed, and if it hasn't been the case, it will be done so very soon. Thank you.
So did I hear correctly? You're just reading it into the record for future debate? Thank you very much. Mr. Bachrach, go ahead, please, sir.
Thank you, Mr. Chair. I note Mr. Sousa's remarks on universal pharmacare, which I very much welcome. I'm delighted that we were able to drag his party kicking and screaming to the place where they're expected to table legislation in the House this week. It's going to be a tremendous win for all Canadians, and we're going to continue to push until that legislation is passed into law so that Canadians can access the kind of benefits that we're talking about today. And I would note, I only have 2.5 minutes, so I'm not going to accept an interruption, but I will note that all three of the stories that were shared with us today about members of the PSAC who've gone through really difficult circumstances, all of them involved medications that they needed to live healthy lives. And I guess my question on that note would be what the government should learn from this experience with Canada Life as it moves towards, hopefully, the timely implementation of universal pharmacare in Canada. What should they learn from the problems they've experienced with this company?
Thank you for the question. Clearly, the provision of benefits in this case has been a major problem. Whatever systems that are in place here obviously will need to be refined and a better understanding of where to go from there. I think it's interesting that the Public Service Healthcare Plan is the largest private plan that exists, with over 1.5 million members, plus many other dependents that are covered under the plan. And so scale, I think, is obviously something that will have to be considered very closely going forward.
Could you elaborate on scale in terms of in what sense?
I think my point really is that when we're talking about provision of benefits for large numbers of people, there's going to have to be systems in place that will respond to that. And so, again, believe that obviously the systems would be different for whatever public plan that will be in place, but that's something that will have to be considered quite closely.
Ensuring that they're prepared for the enrollment process and the rollout of the services under a public plan. I think that's very well taken. Now, Mr. Sousa, in his previous remarks, indicated that the government's working to make things better, and you've acknowledged some improvement over recent months, but it doesn't necessarily address the first question that you brought to us, which was how do we make people whole who have been negatively affected by Canada Life's treatment of their cases and their requests. Does that remain an outstanding piece in your mind, despite the improvements that we've seen?
We're past our time. If you could offer a short answer.
Yes, that absolutely does, and that's something that my colleague, Ms. Hart, has referred to numerous times here, and that's something that we'll absolutely be pursuing going forward. Thank you.
Thank you, Mr. Bachrach. Mrs. Block, please.
Thank you very much, Mr. Chair. I believe the devil is always in the details, and while we have members from two parties here patting each other on the back for something that I think could end up being another boondoggle, I will just point out that you pointed out that you were not given the contract as the representatives of the public service who are members of this plan. What reasons have you been given for not being provided a copy of the contract between the government and Canada Life?
We've simply been told that we're not entitled to that information.
That's very interesting. We have often heard the government's excuses regarding the withholding of documents and actually share in the frustrations of having important information withheld. They have refused to disclose the EV contracts, though they claim they are amazing for Canadians. Have withheld documents across all departments in regards to our McKinsey study, and are being accused of withholding information regarding our ArriveCan study. I guess I'll ask you if you are at least aware of any actions the federal government has taken to date to ensure that Canada Life is at least complying with its contract.
We're, in fact, not provided with that information as well. It's something that we've requested. We will continue to request. But since that 6-month grace period expired as of the start of this calendar year, we're still not aware whether or not they're in compliance with their contract at this point.
So it's really hard to ensure that they are when you don't know what's in the contract and you're not being given any updates as to whether or not they are complying. I'm going to turn the rest of my time over to my colleague, Ms. Kusi.
You have 3 minutes, Mrs. Kusi.
Okay, thank you very much. I talked before about the security clearances as brought up by the Auditor General. In light of the two recent breaches, one including a Canada Life subcontractor, MSH, that was previously brought up by my colleague, are you concerned that subcontractors are not properly vetted?
That's, I think, significantly outside of my area of expertise.
Okay. Were you, my colleague also touched on this, but I'll continue on this. Was your organization consulted on the decision to implement a manual enrollment process instead of the standard automatic enrollment process for public servants? Because this was brought up as a significant choke point in the initial meeting.
You're, I think, testing my memory quite well here, that we have numerous discussions over the last 3 years or so where there's been discussion about a number of issues prior to moving benefits providers, and that included the negotiations, which I believe took well over 2 years to conclude from start to finish. I'm sure there was some discussion at some point about a positive enrollment process. I won't say that we were not consulted, but I will also be very clear and say this isn't something that sticks out very strongly in my mind.
Okay, that's interesting because it was a major point in our first meeting. So then my next question was going to be relative to the stress upon your membership relative to this process and additional strain on the transition. Would you have any further comments on that?
Well, again, our overriding interest here is ensuring that members are able to access their benefits in a reasonable and timely way. What we've seen over the last 8 months now has been some serious problems with that. And again, as improvements happen, we have significant concerns with where this is going. We still see some major barriers out there, and our interest is ensuring that all gets resolved and that members be made whole.
The Treasury Board recently released a new standard for procurement, going back to procurement, which we've discussed here somewhat today, called the Manager's Guide, Key Considerations When Procuring Professional Services. Has this question booklet, would you say, helped the public service reduce its reliance on contractors and provided any clarity to public servants?
A short answer, please.
Again, this is significantly outside my area of expertise.
Thank you very much, Mrs. Kusi. Ms. Sidhu, welcome to OGO. You have 5 minutes, please.
Thank you, Mr. Chair. My questions today will be about the coverage for workers living with diabetes, type 1, type 2, and gestation. Mr. Chair, I would like to ask Mr. Sargent about the continuous glucose monitoring supplies. Specifically, we know that there's a new benefit for the workers with type 1 diabetes. Help me understand the number of workers with the type 1 diabetes who are now covered with this benefit and how this benefit helps them.
Thank you very much for the question. With respect to coverage for diabetes, there were quite a few changes that were made to the plan that some were significant improvements as well as some caps that were insisted upon by the employer that were put on that previously were not there. And so I certainly do not have numbers of the exact number of members that we have who may be suffering from type 1 diabetes, but we did negotiate a number of improvements to coverage for diabetes, and we're certainly pleased to do so, as obviously things have changed quite significantly for members with diabetes and the different types of products out there.
And Mr. Sargent, what is the average wait time for claim processing for continuous glucose monitoring devices, and how can it be more improved?
Thank you. I'm sorry, the wait time, we get general information with respect to wait times just for the call center in general, so that wouldn't be specific to people who have type 1 diabetes or any other specific condition, that there's a call center that people call into that there would be some, that we could provide data on that.
Diabetes testing supplies are part of daily life for Canadians living with diabetes. Could you describe to the committee the claim submission process under the Sun Life and now under the Canada Life Plan?
I think in general, to submit a claim to either company should broadly be the same. I don't think that there would be significant differences between the specific claims process, whether that's a paper claim or an electronic claim, that their processes may differ slightly, but I think in general there's going to be a very similar claims process, and perhaps I'm not fully understanding the question here.
My question was about blood testing requirement and the rationale for removing it.
Sorry, I'm not quite familiar with exactly what there was nothing that was negotiated with respect to that, and so on something this specific, would certainly be happy to, with a better understanding, get back to you in writing.
My next question is about diabetes monitors with the coverage with or without insulin pumps. Could you explain the importance of the provision to the committee for the workers living with the diabetes?
Thank you very much. I think this is a good example of some of the issues that under the previous iteration of the healthcare plan, there were some sometimes outdated or strange provisions of the plan that provided different levels of coverage for someone who was diabetic who used an insulin pump, and different levels of coverage if they did not use an insulin pump. And it was certainly the union's position, and this ultimately was part of the negotiated plan, to get rid of some of these say artificial distinctions in coverage. And as we certainly go forward, we would expect to have continuous discussions about ways that we can amend the healthcare plan going forward to ensure that there are no artificial barriers in place for our members.
I received emails from Canadian describing issues with the information sharing between the old and the new plan. Specifically, the physicians firms submitted under the old plan. What recommendation can you give to this committee to make sure these issues are resolved quickly and claims are processed efficiently?
Thank you. We've heard from a number of members who have provided information from their physicians to the old plan that was not passed forward, and that is of significant concern to us, putting burdens on members financially as well as the Canadian health system generally.
Thank you, Ms. Sidhu. That is our time, colleagues. Ms. Hart, Mr. Sazant, thanks for joining us today. You've been wonderful witnesses. Colleagues, I'm going to suspend for a couple moments to excuse the witnesses, and we can just take a very short break, and then we'll be back in perhaps 5. since we are back in, as we discussed a couple weeks ago that we'd come back to Mrs. Vignola's motion. She was kind enough to agree that we could continue with the witness and then we'd come back to it. After we tend to this, I'm hoping we can discuss schedule coming forward with the SUPs and a few other studies. Mrs. Vignola.
Merci beaucoup.
Thank you very much. This is a motion for producing a document. It's as if I don't have enough to read today. I will read it to you to refresh your memory. The interpreters also have the version with the correct translation. And you also received the motion by email a few moments ago. That, pursuant to Standing Order 108.1, the committee ordered the Government and Public Services and Procurement Canada, PSCP, to produce in both official languages a copy of all contracts, communications, memoranda, calls for tenders, and proposal submissions with GC Strategies in the context of the COVID alert application, as well as all government or internal communications from any government agency or department in connection with the COVID alert application. And that they be submitted no later than March 15th, 2024, provided that these documents are free of all redactions. COVID alert was another application that was developed during the COVID-19 pandemic. And apparently, it was intended to inform you if there was anyone around you who had COVID. And therefore, there was a sharing of personal information. It worked more or less than on the more side, I'd say. And who was behind all of this? Well, in December 2020, GC Strategies received a portion of the contract, whereas this contract did not mention them at the beginning, but they were inserted in December 2020. And so I would like to be able to better understand this matter and how this could have happened. How could people who were only consultants then infiltrate this contract that already existed? Now, this time, did these individuals manage to offer services on par with what was presented, or once again, did they work on resumes and submit names? And in the end, it was to provide something other than what was promised or announced. When we talk about GC Strategies, we're talking about two gentlemen, Christian Firth and Darren Anthony, two men who were also the owners of a company, Corrida Systems Consulting. And I have another motion for producing documents for this company as well. I think we're best to start by debating the motion I just tabled, and then I will discuss the Corridal motion afterwards.
Do we have any wish to speak on it, or are we fine with the wording of this document or this motion?
Yeah, I just want to point out is that
So I think we understand. Yeah, Mr. Backrack?
I'm just wondering, in the English translation of the motion, the last clause states, provided that these documents are free of all redactions. And is that the same point Mrs. Block was just making?
No, separate one. I was chatting with the clerk about that. That's kind of a translation thing. I think
Okay.
the intent is that
It should be,
provide
and
to
that these
us.
documents shall be free of all redactions.
Yeah, I think the
Okay.
French communicates that better.
Yeah, that was my
So
assumption.
that is the intent. And of course, it also says PSPC or PSCP, but it's intended it's PSPC. But good point, Mr. Backrack. Are we fine with this, colleagues? So we can say, Mr. Kuzmierczak?
Yeah, I just wanted to, I I do have an amendment that I wanted to bring forward. I think we're in general agreement with the thrust of this motion. And again, I thank Madame Vignola for bringing it forward. What I would ask is that the first part of the amendment is that the following be removed after all contracts. Sorry, it says here copy of all contracts. And if we can remove the following communications, memoranda, calls for tenders, and proposal submissions. And I do have another amendment that we can discuss after this amendment.
Your amendment is to eliminate communications, memoranda, calls for tenders, and proposal submissions?
Yes, that is correct.
Okay.
That is correct.
Ms. Vignola, on the amendment?
Oui, sur l'amendement.
Yes. I understand my colleague and his wish to not be overwhelmed by a tremendous quantity of communications. I understand that completely. Nonetheless, around a contract, well, getting details on COVID alert, for example, appointments at the restaurant, whiskey meetups. When we want to get an overall idea of what's happening, and when we can get an overall idea, we can better understand the context. And that's why I've asked for all of these documents. Because they are all connected to COVID alerts. It's to give us a better overall picture. If we just have the contract, we won't have the full context of how they managed to get added to a pre-existing contract.
Mr. Kuzmierczak?
I very much appreciate what Madame Vignola is saying here today, and I think she hit the nail on the head when she said that my concern here is, again, we're going to be overwhelming the folks that produce this material, and our focus right now is on the contracts. Let's take that first step. Let's look at what the contracts have to say. Let's see what is in those contracts. That is the focus of our study, and then make that determination before we again overwhelm the system with a production request that is going to produce, like you mentioned, Madame Vignola, an overwhelming amount of documentation. I think the contracts will give us a foundation from which to work on. I think that's the first step. We'd like to see this proceed. We think it's a good motion, and it's a good necessary step forward. But again, like I said, we want to balance it out with making sure that we judiciously, responsibly ask for documentation. I think the contracts is a very good step.
Entendons-nous que nous...
Well, let's agree that we won't agree on this. I'm talking about context. I understand my colleague's concerns, but the contract will not give me the context around how the contract was awarded. I need context as well to really understand that contract and how it all unfolded. So we're not going to come to an agreement on this sub-amendment, unfortunately. I understand the quantity of documents involved. I spend my days working on this. I do completely understand that. However, I need context in order to do a complete and unbiased analysis.
Mr. Kuzmierczak's amendment.
We're talking.
We're talking on Mr.
We're talking about the
Kuzmierczuk's
amendment to it.
which is to take out communications, memoranda, calls for tenders, and proposal submissions.
Yeah, if I may.
Yep, go ahead, Mr. Souza.
Yeah, I appreciate the concerns that we're trying to obtain as much information as possible to determine how it came to be in respect to some of these contracts, and certainly it's appropriate. That's why we've been at this committee for some time relative to this. But I think we've already had some concern that has been expressed even by the chair in terms of the volume of translation and material and information that we've asked for production. And for us to now go back and ask again for more in light of the fact that we have quite a bit of information already on hand that hasn't determined what I think we're trying to obtain. I just don't want us to find ourselves bogged into a situation of futility when we are currently under a matter of investigation by a number of bodies, and we certainly have taken quite a number of steps to try to obtain some information. But all the material, all the communications from a number of departments that may or may not be related to this, and while we're trying to suggest that it be so, it becomes quite a undertaking. And I think we've already been requesting some of this. So the scope is so broad in its request that I think we need to be more specific, and that's why some of the amendments made by my colleague I feel is appropriate in order to sort of delve strictly in terms of what is being discussed here and trying to get to the bottom of how that decision came to be. So this is one amendment. I think probably will have yet another, but I propose that we take this amendment and proceed forward so we can get as much value from our request of the civil service to divulge information. Thank you.
Ready to vote on it? Yeah, we're voting on Mr. Kuzmierczuk's amendment.
On the amendment to delete the words, Ms. Sidhu.
Yes to the amendment.
Mr. Baines. Yes. Mr. Johari.
Yes.
Mr. Kuzmierczuk.
Yes.
Mr. Souza.
Yes.
Ms. Block.
No.
Mr. Janus.
No.
Ms. Kusi.
Against.
Madame Vigneault.
No.
Mr. Backrack.
No.
Mr. Chair, 5-5-5.
No.
Then yeas 5, nays 6.
So we're back to the original motion. Colleagues, are you comfortable with me perhaps offering a compromise? Move it up to March 1st. So I understand Mrs. Vignola's issues, but I understand what you're saying as well about the amount of documents by the 15th that we're not going to get by that time, is perhaps ask for contracts, the RFPs, and the proposals, and perhaps move the time up a bit. That greatly reduces the amount. And then with a promise that we immediately revisit the motion when we're back if Mrs. Vignola needs more context. So rather than the communication memoranda, but contracts and RFPs and submissions. Yeah, sir.
I guess it's
and
hard
it's
for me.
just open for discussion was all.
I appreciate the attempt to find a compromise. It's difficult to know where to land on this because, of course, we don't know how many documents we're talking about. Perhaps previous document orders have given people a sense of the volume that we're talking, but I think we both want it to be realistic in terms of the timeline and get the answers that the committee deserves and the public deserves. So my instinct would be to keep it broad as Ms. Vignola has outlined in her original motion. I have no idea the practicality or practicability of that. And so I'm hesitant to support trimming it down without knowing whether that's necessary. How many emails can you send about a topic like that? Hard to say.
It's hard to say. I'm just thinking of being realistic of the time and then translation services as well. Like it's taking us 3 days just to get a 1-page letter translated. So that's my concern about the date. So that's why I'm just putting it out there. So just from a pragmatic point of view. James?
In addition to the translation, the magnitude of the documents, I'm concerned about the cost associated with producing them and translating and doing that. So I just wanted.
Yeah, I don't think it's an issue. We're going to go back to the amendment's been defeated. We'll go back to the original motion. I just put out a solution, but we'll go back
I do
just
have
to
another
keep her
amendment.
proper. Okay.
Okay, so I do have, I'd like to bring forward a second amendment. And again, this one here is regards the last sentence, and it would delete the following after COVID alert application, and it would delete the following, as well as any government or internal communications from any government body or department related to the COVID alert application. And if I can speak to it very quickly. Sure, I'm trying to get my computer up and running in just a second because it. Deleting, and I'll quote. This is after the words COVID alert application, and also
in the context of the COVID alert application.
Right. The second part. Sorry, I do apologize because my computer right now is decided to turn off. But I'll quote the words.
Or departments in connection with the COVID alert application, comma.
As well as any government or internal communications from any government body or department related to the COVID alert application. So delete the words as well as any government or internal communication from any government body or department related to the COVID alert application. Does that make sense, Chair?
So in the context of the COVID alert application, and that they be submitted no later than March 15, 2024, provided that these documents, that the documents are free of redactions. Is that correct?
Yes.
Yeah, that's correct.
That's correct.
Mrs. Vignola on the amendment?
Yeah. Let's go.
Well, of course, that automatically removes a lot of information and documents. And I can understand that. In the very least, we would have the communications from Public Services and Procurement Canada and from GC Strategies, but we wouldn't have those from the other departments. But I would include, COVID alert is health. So health is in charge of this, the health department. So perhaps that would be the compromise I would propose. Instead of putting all the communications of all the government bodies with COVID alert and GC strategies, I would at least include health because they're in charge, along with PSPC, of this application.
Proposing a sub-amendment, Ms. Vignola?
Yep.
Okay.
And so it would be with GC strategies and PHAC? What is she says?
Are you saying that proposal submissions with GC strategies and PHAC? Or what are you?
What else? She's talking about what?
Ce qu'on pourrait lire, c'est que conformément
Pursuant to Standing Order 108.1, the committee orders the Government and Public Services Procurement Canada and Health Canada, who's in charge of the application, to produce in both official languages a copy of all contracts, communications, memoranda, calls for tenders and proposal submissions with GC strategies in the context of the COVID alert application, and no later than March 15th, 2024, provided that these documents are free of all redactions.
Est-ce que c'est plus clair pour vous?
Is it clearer that way?
Mr. Kuzmierczak's amendment, but you're just changing to PSPC and Health Canada.
And Health Canada.
Yeah. So the idea is to accept Ms. Vignola is accepting your amendment, but sub-amending it to be Health Canada and PSPC. Is that correct? Yeah.
Yeah, Mr. Chair, I do appreciate that we're working through a compromise here, and I think we've shown in previous meetings, including last week's meetings, that we all actually work well together and we find a path forward. Again, on this one, all internal communication, all memos. My concern is, again, we're going to be committing staff and resources to basically going on an expedition here every time the word alert is mentioned. And I think this has a potential. Again, we've asked for production of papers. This committee has asked for production of papers in the hundreds of thousands of pages for previous studies. And on this side, on our side, we've agreed to a lot of that production of documentation. But I'm looking at what it has delivered and compared to what we have asked in terms of the resources and the commitment that it's taken. And I don't see the cost benefit of that. The cost is tremendous. I mean, again, hundreds of thousands of documents that we have already asked for that are in the process of being provided, being translated, being sent out and distributed to committee. And again, my concern here is fairly simple. Is I think the intent of the original motion we agree with. We want to take a look at the alert app, and we want to look at the especially as it pertains to GC strategies, and I think looking at the contracts. And looking at the, as the chair suggested, RFPs, all of that makes sense. But again, here we're going to be basically assigning precious resources and staff to basically go on an expedition. And that's what I'm concerned about. And I think we have to be judicious. That's part of our role here, is we have to be judicious. If there is something that we find in the contracts, in the RFPs, that requires or prompts us to ask for additional information, I think that makes sense. But to do this all at once here at the start of this, I think the cost-benefit analysis doesn't bear it out. And it puts incredible stress and strain on already depleted and stressed and strained resources. And again, hundreds. We're not talking a few pages that we've asked for. We've literally asked for hundreds of thousands of documents to be provided this committee. So I ask my colleague, who's been very reasonable and pragmatic and patient, I may add, on previous motions that were brought forward, to work with us. We have a motion that I think we could all support, which is always wonderful to see when we have unanimous support. But let's bring a motion forward that is more surgical, to bring a motion forward that is more specific, that is balanced, and that doesn't close the door for additional production of papers if the more refined, surgical, and specific motion finds evidence that requires that. And so again, we're not closing the door on an expanded production motion, but let's be surgical, let's be responsible, let's be pragmatic, And hopefully, let's pass this motion unanimously because we think that it is. I think the spirit of the original motion is a good one.
We'll go to Mr. Genuis. Just to be clear, technically, Mrs. Vignola's sub-amendment isn't really a sub-amendment because it doesn't change Mr. Kuzmierczuk's amendment. But the will of the committee can consider it as such if we choose to. Mr. Genuis, go ahead.
Before I get into my substantive comments, Chair, I do think we should avoid the kind of procedural fuzziness that has happened previously. We should have amendments, sub-amendments that change amendments, and we should have separate amendments that can be moved once previous amendments are defeated, because I think we did get into a situation where there was some confusion about the result. So I think the will of the committee would be to operate in accordance with the established procedures around amendments and sub-amendments.
Let me just interfere, or let me just interrupt. We will come back to you, Mrs. Vignola, after we deal with the amendment, and then we can perhaps make a change as discussed. So we will go back to just debating Mr. Kuzmierczuk's amendment. Go ahead, Mr. Genuis.
Okay, thank you. So Ms. Vignola has, I think, tried to engage in a certain spirit around compromise, but fundamentally, I don't think the Liberal members across the way are that interested in a compromise. They're proposing to amend a document production motion to effectively make it not order the production of the documents that would be required to answer the basic questions that are involved. So in the absence of an apparent will to compromise from the members across, I think we should just pass the original motion that Ms. Vignola put forward. The original motion was a good motion. We support it. Let's get on with doing what I think a majority of this committee are interested in doing. The broader picture, Chair, is that as we prosecute the Arrive scam scandal, we see that Liberals are so concerned about resources when it comes to the small matter of producing documents for a parliamentary committee, but seem completely unconcerned about the use of resources that were involved in this scandal in the first place. $60 million spent on an app is no problem, according to them, but trying to actually get the documents that would allow a parliamentary committee to investigate it is suddenly a resource issue. This is what's going on. This is the bearing of information that we continually see from the Liberal government. But we have a majority on this committee that wants this motion to pass, so let's just pass it in its original form. Thanks.
It's Mr. Sousa, then Mr. Kuzmierczuk. Okay, do you want to speak after?
Yeah, thank you, Chair.
He's going to talk about what I want.
Okay, thanks.
Yeah, thank you, Chair. And again, like I said, we're trying to find a balance here. And contrary to what Mr. Genuis has said, we have been good partners throughout, whether it's on the Arrive Can app, whether it's on the study of what we just talked about this morning in terms of the Canada Life issue, whether it's this issue. We have been good partners. We're always looking to move forward, and we're always looking to be, if we need to produce documents, we agree to it. If we need to call witnesses, we agree to it. We've been good partners every step of the way. That's been our track record. We're trying to do it responsibly. We're trying to balance it against, again, the stress and the strain we know is being placed on resources and translators. Having said that, and upon reflection, I believe that Madame Vignola's compromise is one that we can agree to. We think it does restrict. We believe it does restrict the broad scope of the original motion, and it makes the motion much more specific. And so for that, we want to be able to find a way to move from my amendment to what Madame Vignola has suggested, as long as if I could maybe, if it's possible, to maybe read out what. To read out where we're trying to get to, and then maybe work with the chair and the clerk to find a path forward for that. Is that okay?
You're going to read what you...
Yes.
Yeah, please go ahead.
So what we're trying to get to,
this
and I don't
is
know,
not on the amendment. This is what you're proposing we get
this
to.
Is what I'm trying to get to this point, and I'm wondering if Madame Vignola would agree to it. And so And so the amendment would read that pursuant to standing order, or excuse me, the motion would read that pursuant to standing order 1081, the committee order the Government and Public Services and Procurement Canada, PSPC, and Health Canada to produce in both official languages a copy of all contracts, communications, memoranda, calls for tenders, and proposal submissions with GC strategies related to the COVID alert application no later than March 15th, 2024, provided that these documents are free of any redactions. And so what it does, it accomplishes the, we're trying to do here, which is basically narrow in scope a little bit the original motion, which was just so broad, to focus on PSPC, to focus on Health Canada, tighten it up a little bit in terms of what is the focus of the motion. Does that make sense?
Yeah, it does. You would have, to get there, you would just have to withdraw your amendment and then we'd redo that.
Happy to withdraw and ask for UC to withdraw that amendment.
Okay.
Great. So invite UCC to withdraw both your amendments, actually, if you.
Well, the first one was voted on and it was already voted.
First one was defeated. So you're withdrawing, we have UC to that. Can we assume that he has read in his new amendment? Why don't we just, I'll have the clerk just read it back a final time to make sure we're all aboard with the amendment that Mr. Kuzmierczak is proposing. And I thank you for the compromise, sir.
So with the second amendment being withdrawn, what you see, and a new amendment being proposed, it would read that pursuant to Standing Order 1081, the committee ordered the Government and Public Services and Procurement Canada, PSPC, and Health Canada to produce in both official languages a copy of all contracts, communications, memoranda, call for tenders, and proposal submissions with GC strategies in the context of the COVID alert application, and that they be submitted no later than March 15, 2024, provided that these documents be free from redactions.
Yeah. You're fine with that? So we'll approve the amendment?
No. We've heard the amendment, but we don't support the amendment.
Well, that's what I'm asking. Yeah, if we could, so no, you wish to.
We can vote on the amendment, though.
Yeah. Okay, let's vote on the amendment then. Go ahead.
All right. So the terms of the amendment is understood, it's clear? Okay. Ms. Sidhu.
Yes. Yes to the amendment.
Mr. Baines.
Yes.
Mr. Jouari.
Yes.
Mr. Kuzmierczak.
Yes.
Mr. Sousa.
Yes.
Ms. Block.
No.
Mr. Janus.
No.
Ms. Guzzi.
Against.
Madame Vignola.
Pour.
She said pour. 4. Mr. Backrack.
In favor.
Yeas 7, nays 3.
Yes, sir.
I think we're back to the motion as amended now, if I'm correct.
That is correct.
I still have just that outstanding concern about the language at the end. It seems like when we're reading it back, we still have the English version, which is provided that they are unredacted. And by my read, that would suggest that if there are any redactions, they don't have to provide any of the documents. So I would prefer the wording.
Clear, so.
And that these documents be provided free of redaction, I think would achieve in English what we're trying to do.
We're in agreement with that, colleagues? No need to vote? Wonderful. Just vote on this now. Yeah. And that these documents be provided free of redactions. Right.
Okay.
Okay. Can we vote on this as amended?
motion as amended.
Okay, I guess we'll finish here. I'll figure it out after, excuse me.
No more debate?
Nope.
So the vote is on the motion as amended. Ms. Sidhu,
Yes.
Mr. Baines,
Yes.
Mr. Johari,
Yes.
Mr. Kuzmicek,
Yes.
Mr. Sousa,
Yes.
Ms. Block,
Yes.
Mr. Ginnis,
Yes.
Ms. Kusi,
In favor.
Madame Vignola,
Pour.
Mr. Backrack.
In favor.
All yeas, Mr. Chair. Tout les pour.
So adopted. Thank you very much, colleagues. Before we break, just quickly on this upcoming schedule, the supplementary Cs have come out. Yay! Because I am a estimates geek. I'm trying to schedule in. We've put out invites to the ministers. As always, we will work around the scheduling of the ministers. We've trying to get, TBS is not available Wednesday. We are trying for PSPC for this Wednesday. Otherwise, we've got the 18th and 20th, so we'll try to work around that. We've sent out an original invite to kick off Canada Post. Just waiting to hear back, so we'll fit that in. And then we are going to be sending out invites very, very soon regarding the red tape reduction. If everyone will allow me just the discretion to work with the last week of March and the first 2 weeks of April, so we can fit in the ministers for the estimates, usually the PBO.
No.
Sorry, the 18th to 22nd of March, the week of the sitting week of March. I apologize. The intent is we'll have the PBO for an hour as usual. The ministers, and their attending staff for the second hour as well. Canada Post, when we can nail down the president of Canada Post, which will kick off our meeting, kick off with red tape, and we'll squeeze that in. We don't know when the last supply day is, but we still bring in the ministers on their estimates even after the last supply day, as is our custom. So we'll work around that if everyone's comfortable. Mrs. Vignola, did you have your hands up regarding?
Je voulais justement parler de la...
I wanted to talk about the first week of March to make sure, along with my colleagues, that even though I love seeing them, despite the fact that it's whether it's a parliamentary week or not, the first week of March, I would like us to have the choice to be available in our ridings. If we could agree on that, we could freeze that week as a group. So we want to make sure our children aren't putting our faces on a milk box. The milk cartons, rather.
You think that's going to make a difference? You really think that's going to make a difference?
On the milk box, have you seen my MP? We will do our best. Yes, sir.
Looking at the calendar, when would we start the red tape study?
I'm hoping to get Wednesday is our cutoff date for red tape witnesses. As soon as I get the witness list, I think we know who wish to prioritize. I'm getting a sense CFIB chamber type person, depending on when the ministers would be available. Because the ministers, because we have to work around there, will trump. But I'm hoping, depending if we can get someone for Wednesday, I'm hoping March 18th week or April 8th week. But again, depending if a minister is available, that is going to bump the others because
that makes sense.
We need to get that.
That makes sense. Okay.
So if you could work on your side for the ministers, we'll go from there. Colleagues, thank you very much. I appreciate it. It was a very good meeting. We had wonderful witnesses again today. I want to thank our fill-in clerk, filling in for our two other clerks who are both sick today. Thank you very much, Ms. Vol, and of course, our valued interpreters and our valued analysts. Thank you, everyone. We are adjourned.